This is the case of the application of the Convention on the Prevention and Punishment on the Crime of Genocide. The presentation will include the statements from the parties involved, including Bosnia and Herzegovina versus defendants Serbia and Montenegro, as well as the ruling of the International Court of Justice. The breakup of Yugoslavia was a process in which the republic was divided into constituent republics and over the course of which the Yugoslav Wars began. The European Community recognized the Republic of Bosnia and Herzegovina on the April 6, 1992, as an independent state following the elections held in 1990. The election resulted in a coalition government split between parties representing the Serbs, Croats, and Muslims. However, the Bosnian Serbs wanted to be part of a dominant Serbian state in the Balkans, the Greater Serbia, that Serbian separatists had long envisioned. The violent acts that occurred in Bosnia and Herzegovina by Serbia and Montenegro started in April of 1992, targeting Bosnian Muslims, and the atrocities intensified through May of that year, killing around 150,000 Bosnian Muslims and displacing over 2.6 million people. On March 20, 1993, the Bosnia and Herzegovinian government instituted proceedings against the Federal Republic of Yugoslavia to the Court of Justice concerning their violations of the Convention on the Prevention and Punishment of the Crime of Genocide of Bosnian Muslims. To condemn Yugoslavia, Bosnia and Herzegovina submitted the following request for the court to adjudicate and declare that, first, Yugoslavia had violated and is violating the Convention on the Prevention and Punishment of the Crime of Genocide, Articles 1, 2, and 3, by destroying in part and attempting to destroy in whole national and ethnical or religious groups, particularly Muslims within the territory of the Republic of Bosnia and Herzegovina. Next, the Yugoslavia government must immediately cease the above conduct and take immediate and effective steps to ensure full compliance with its obligations under the Convention. Furthermore, Yugoslavia must restore the situation existing before the violations of the Convention were committed. And finally, Yugoslavia is required to pay Bosnia and Herzegovina full compensation for the damages and losses caused.
On behalf of Yugoslavia, these are the following objections. The Federal Republic of Yugoslavia asked the court to adjudge and declare these main objections. The application by the so-called Republic of Bosnia and Herzegovina is not admissible because, first, the violence that ensued in the region does not fall under international law because it is a civil war. Furthermore, Alija Izetbegović was not officially the president of Bosnia and Herzegovina at the time when the application was made, nor was the state recognized as legitimate, thus making the application not admissible. In addition, the so-called Republic of Bosnia and Herzegovina had not ratified to the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, meaning that it is not state party to the convention and consequently the court has no jurisdiction over this case. Even if the so-called Republic of Bosnia and Herzegovina expressed the intention to enter the convention, the court would only have jurisdiction over this case as of March 29, 1993, and thus the applicants claimed the alleged acts occurred prior to the date do not fall within the jurisdiction of the court.
However, taking into consideration the initial objections from the defending party of Yugoslavia, the court will rule in opposition to their objections on the following grounds. First off, regarding the claims concerning Bosnia and Herzegovina's lack of statehood at the time of their application, it is found inadmissible due to the UN recognition of independent statehood on the 6th of March 1992. Dismissing the second objection as well in reason that the time of the filing of the application, Mr. Izetbegović was recognized in particular by the United Nations as the head of state of Bosnia and Herzegovina. The court also observes that the reference in Article 9 to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3 does not exclude any form of state responsibility, including any form of state organ or leader. The court must dismiss this objection. The court must also negate the proposition of jurisdiction prior to the 29th of March, 1993, yet the date does not matter because the parties involved did not make any reservation in the Convention or the Dayton Paris Agreement that the court will be limited in jurisdiction to this case. All facts presented in the claims are relevant. The court hereby finds Yugoslavia's claim inadmissible therefore holds the jurisdiction to consider the merits of Bosnia and Herzegovina's claims. The court rules pertaining the requests made by Bosnia and Herzegovina that Yugoslavia has and is violating the Convention on the Prevention and Punishment of the Crime of Genocide. They must immediately cease the above conduct and make reparations to the crimes it committed against the Convention. By 13 votes to 2, the court finds the application from Bosnia admissible, and the International Court of Justice has jurisdiction.